When you file for bankruptcy, the law creates what's known as a trust. If you think about it, you're familiar with this concept, as when someone is referred to as a trust fund baby. Now, the legal definition of a trust is a legal entity where a trustor, who's the person setting up the trust, transfers ownership of their assets to a trustee, who then manages these assets for the benefit of a third party, known as the beneficiary. Now, here's an example. Let's say wealthy parents want to one day transfer their portfolio of rental properties and stocks, their wealth, to their children. But they don't particularly trust that their kids will be able to manage these things properly. They'll waste them. So they hire a lawyer and create a trust and transfer their assets to it. The legal title and control of the trust and the property within now transfers to their lawyer or anyone that they trust, hence the name trustee. Now, the trustee manages the property for the benefit of the kids, who are referred to as the beneficiaries. During the lifespan of the trust, the children can be paid from the property, but they can't take over it, control it, or request more money than what is outlined in the trust documents. The parents, too, can't take back what's in there in case they change their minds. When you file for bankruptcy, the law creates a similar trust to hold your property. But of course, there are some major differences. The first is that the trust is referred to as the estate, and the trustee is a lawyer, a local lawyer, picked from a panel of certified bankruptcy lawyers. Now, these trustees are sometimes called trustees in bankruptcy. The second difference is that the beneficiaries in the bankruptcy are your creditors. And just like the children of those wealthy parents can't take control of the property without the trustee's consent, creditors too can't take a debtor's property unless a judge permits them. And just like the parents can't change their minds and take back their property, debtors too cannot take back their property, with some exceptions I'll cover later. The second important thing that happens is that the law grants you something called an automatic stay. Now, this is one of the most potent tools available to you. It's a court order that requires all your creditors to stop collecting against you. And it also pauses most lawsuits filed against you. Now, with this pause in place, your creditors can't enforce old or new judgments against you or attempt to take any property away from you. Now, there are, of course, some exceptions, which I'll cover later, but what's important here is that the automatic stay, in many ways, freezes your financial situation to give you a breather and to allow the court and the trustee to begin managing your case. I want to dedicate some time to the trustee, who's a critical party in a bankruptcy case. In general, the trustee administers your estate by gathering all your assets, with some exceptions. In what's known as a Chapter 7 liquidation case, the trustee sells your assets to pay back your creditors. On the other hand, in what's known as a Chapter 13 repayment case, the trustee administers your payments to your creditors over the years of your repayment plan. Trustees have a special obligation to your unsecured creditors, who are usually credit card companies and medical service providers. Now, these creditors are referred to as unsecured creditors because whatever money they loan you isn't secured by any collateral or any property. For them to get anything from you, they will need to go through a complex legal process, including suing you in court. A secured creditor, on the other hand, is a bank or a home lender that loaned you money for your home and can take away your home if you don't pay it back. Now, in this arrangement, your home serves as the bank's security or collateral, which is why they're referred to as secured creditors. In bankruptcy, the differences between secured and unsecured creditors are quite important, with each having different rights under the law. Trustees have a special obligation to unsecured creditors because, unlike secured creditors, they had no collateral to take. The trustee therefore manages the many creditors that have claims against you and ensures that no creditor gets more than their fair share. Now, given this responsibility, The trustee will investigate your financial affairs to ensure that you aren't hiding assets or underreporting what you earn. It's for this reason that I ask for my clients to give me a full financial picture. I need bank statements, tax returns, and all other key financial documents. With a full picture, I'm much more helpful than if I didn't have one.